Does the Equal Protection Clause of the 14th Amendment prohibit race-conscious affirmative action?
The Equal Protection Clause of the 14th Amendment does not prohibit race-conscious admissions policies. The purpose of the 14th Amendment was to reintegrate formerly enslaved people into the Union. And as we'll explain in question 2, the framers of the 14th Amendment clearly intended to help the historically marginalized and powerless groups and would have supported race-conscious admissions policies. And although it's true that this court doesn't restrict the meaning of the 14th Amendment only to those contexts which were explicitly intended by the framers of the 14th Amendment, the intention of the framers is important in at least two respects. First, it would justify getting rid of tiered scrutiny altogether, as it recently did in Bruin, when the court, quote, did not engage in means-end scrutiny when resolving the constitutional question, but instead focused on the historically unprecedented nature of the decision in question. Likewise, the historically unprecedented nature of Baki's application of strict scrutiny to race-conscious admissions may impel this court to replace means-end scrutiny with a standard wherein this court, as it did in Bruin, quote, assesses the lawfulness of race-conscious admissions, quote, by scrutinizing whether it comported with history and tradition. And of course, no particular policy is before the court today, but it's clear that this court will find that most, if not all, race-conscious admissions policies have a lot of historical precedent in the framing era. At the very least, petitioners' claims that no race-conscious admissions policies are allowed under the Constitution will be proven clearly erroneous. Secondly, the framers of the 14th Amendment specifically intended to redress discrimination against a historically oppressed and politically powerless group. This disproves Baki's claim that, quote, racial and ethnic distinctions of any sort are inherently suspect and thus call for the most exacting judicial examination, and furthermore, that this perception of racial and ethnic distinctions is rooted in our nation's constitutional and demographic history. To the contrary, the historical evidence clearly shows that Baki's view that does not distinguish discrimination that helps powerless and marginalized people and discrimination that hurts minorities who are powerless and marginalized actually has no basis in the history of the 14th Amendment. How does legislation enacted by Congress in the 1860s and 70s affect your answer to question 1?
Legislation enacted by Congress in the 1860s and 70s reaffirms our answer that our race-conscious laws are constitutional. These laws demonstrate historical precedent for explicitly race-conscious laws not only being permitted by the 14th Amendment, but being promoted by the very same people who wrote the amendment. The Civil Rights Act of 1870, which the 14th Amendment was directly derived from, is instructive in this sense. It reads that all persons within the jurisdiction of the United States shall have the same rights as are enjoyed by white citizens. The specific pointedness of the act had the effect of allowing race-conscious policies that benefited the historically marginalized minority group. Indeed, Senator Trumbull, who was instrumental to the crafting of the Reconstruction-era amendments, said the law is for the relief of the persons who need the relief, not for the relief of those who have the right already. For example, the Freedmen's Bureau Act directly gave benefits to Black individuals in both social and educational contexts. Congress, for example, created schools specifically for Black people called freedmen's schools, monitored labor deals between Black people and other races, and distributed resources to Black people in a targeted manner. Indeed, many of the arguments which the opponents of the Freedmen's Bureau made are echoed by the petitioner today. President Johnson, for instance, who vetoed the bill, accused it of being founded for one class or color of our people more than another. But the framers of the Freedmen's Bureau, who would go on to frame the 14th Amendment itself, were strongly opposed to this line of reasoning. They responded the very object of the bill is to break down the discrimination between whites and Blacks and to make possible the amelioration of the condition of the colored people. It is very clear what the intentions of the framers of the 14th Amendment were. They specifically meant to address racist laws disadvantaging historically marginalized Black individuals in an attempt to reintegrate them into society. They would be appalled to see their amendment misunderstood to ban race-conscious admissions policies meant to help the same historically marginalized individuals and prevent systematic racism from continuing in the future. As we explained in the previous question, the intention of the framers is not disputed, but it is an important factor we must consider when interpreting the 14th Amendment. This course has failed to consider this intention in Bakke, and therefore we ask that Bakke itself be overruled. Let's assume that the framers of the 14th Amendment concluded that race-conscious legislation was constitutional in the 1860s and 1870s. Would that argument still work more than 150 years later in a very different society?
Yes, because respondent doesn't argue that the framers of the 14th Amendment had specific intentions in mind, and therefore that we today should limit the 14th Amendment to only apply to those specific intentions. In contrast, respondent just argues that the framers' views provide strong evidence to disprove Bakke and petitioners' erroneous claims about the historical context of the 14th Amendment. It can indeed be argued that the bar for race-conscious admissions should be higher in the modern day than it was in the 1860s, and both frameworks that respondent proposes allows for this flexibility. Intermediate scrutiny allows for the consideration of the importance of the government interest, and the historical standard allows for a holistic analysis of a historical law and its context in order to set a standard for the modern day. But what's indisputably false are claims that the framers would have opposed all forms of race-conscious admissions, as the petitioner does, or that the framers would approve, as Bakke claims, of an identical standard for laws that disadvantage marginalized minorities and laws that help those same minorities. Let's assume that the framers of the 14th Amendment thought that people of African descent deserve certain race-conscious privileges because of the unique context of slavery. Would the framers have also argued that members of other races, such as Hispanics, Asians, and Native Americans, should receive similar privileges?
There's no way to know exactly what the framers would have believed, but we can apply the standard which the framers set to these other contexts. Many of these groups, like African Americans, are what this court described in Caroline products as discrete and insular minorities, with no recourse to the majoritarian political system. Both the founders and this court in cases such as Reed v. Reed and Frontiero v. Richardson have ruled that historical discrimination is a pertinent factor in determining whether a law is in violation of the 14th Amendment. Many of these groups, like African Americans, have in fact been subject to historical discrimination, often from the government itself. These factors point strongly towards at least some sort of consideration on the basis of race being afforded to these groups. What would the framers of the 14th Amendment have thought about affirmative action policies that benefit people on the basis of sexual orientation or gender identity?
As we said in the previous question, it's impossible to know exactly what the framers would have thought about policies that benefit those of certain sexual orientations or gender identities. But again, we can extend the standard they set to these cases also. Like in the context of races other than African Americans that we explained in the previous question, laws that benefit groups which are discrete and insular minorities and have been subject to historical discrimination, such as many sexual minorities, should be treated more leniently than laws that hurt these groups. Does Brown versus Board of Education prohibit race-conscious affirmative action? In your answer, please address Bakke and Grutter.
Certainly not. The Topeka law in question in Brown v. Board of Education is the opposite of the intent of race-conscious admissions programs. While Brown sought to exclude minority groups from society, race-conscious admissions programs hope to include racial minorities into colleges and universities. More concretely, Bakke set the opposite extreme from Brown. This court's holding in Brown was that segregation deprives the equal protection of the laws guaranteed by the 14th Amendment, that any language in Plessy v. Ferguson contrary to this finding is rejected. But this court clarified in Bakke that states did not have limitless authority to promote policies that furthered integration. Rather, the court wrote that although the goals of integrating medical profession and increasing the number of physicians willing to serve members of minority groups were compelling state interests, states were mandated to use the least intrusive means of achieving those goals. Grutter merely applied the standard that Bakke laid out here, but found that diversity that furthers a compelling state interest and that Michigan Law School's admissions program bears the hallmarks of a narrowly tailored plan. In other words, Grutter applied Bakke's test to the specific case of Michigan Law School's admissions policy and found that the law school's admissions policy was acceptable under Bakke's standards. The respondent today argues in favor of Brown and opposes Bakke, only insofar as we believe it is too strict of a standard. A respondent believes that more leniency should be given to schools attempting to follow Brown's mandate to racially integrate and diversify the nation's schools. In 2003, Grutter observed that 25 years after this case, the use of racial preferences will no longer be necessary to further the interests approved today. Will there ever be a point in time which racial preferences are no longer needed? If not, should the court allow racial preferences to go on forever?
We are confident that there will be a day when race-conscious admissions are not needed to have diversity on college campuses. However, we're disappointed to say that Grutter's time frame was over-optimistic and that now is not the time when race-conscious admissions are no longer necessary. All sorts of statistics tracking racial differences in education, economic standing, and employment all demonstrate the continued need for race-conscious programs. Indeed, a recent study showed that because of the long-standing effects of past racial discrimination, the number of Black students who would be admitted to several prestigious universities would more than halve, but for race-conscious admissions policies. Once these statistics change to suggest that Black Americans have reached a place where they have an equal chance to succeed as white Americans, race-based programs can be eliminated. Until then, it remains a necessary and important interest of the government to make sure that our universities are diverse, using race-conscious measures if necessary. Should Grutter v. Bollinger be overruled? Please address the Supreme Court's recent discussion of stare decisis in Dobbs against Jackson Women's Health Center.
Grutter should be overruled only insofar as Bakke should be. However, if the court does not overrule Bakke, it should not overrule Grutter. Grutter correctly applied strict scrutiny in that the University of Michigan's admissions policy did in fact address the compelling government interest of diversity using a narrowly tailored means. However, Grutter was wrong to apply strict scrutiny in the first place. This court should therefore overrule Grutter in part. This court in Dobbs gave us three factors which we should consider when deciding whether or not precedent should stand. Furthermore, it reemphasized a principle that this court has often abided by, which weighs in favor of respondents. The three factors which Dobbs gave were the following. First, the correctness of the decision and the persuasiveness of its logic. Second, the impact of overruling the case on other areas of the law. And third, the reliance interest which overruling the decision would unjustly or unduly upset. Furthermore, this court in Dobbs emphasized that stare decisis is not an inexorable command, and it is at its weakest in constitutional cases, just like Bakke. Because all three factors counsel in favor of overruling Bakke, Bakke is neither correct nor convincing. Overruling Bakke does not impact other areas of the law, and replacing Bakke with respondent's proposal would not upset any reliance interests. And stare decisis is already weak because of its constitutional nature. This court's stare decisis analysis advises in favor of overruling Bakke. If the court declines to overrule Grutter, can the plaintiffs prevail?
Although it would be a less than ideal decision for respondent if the court upheld Grutter in full, plaintiffs still cannot prevail in this case. Grutter clearly states that, quote, the law school's use of race in admissions decisions is not prohibited by the Equal Protection Clause. Petitioner today argues that all admissions processes which use race are prohibited by the Equal Protection Clause. If Grutter is correct, petitioner cannot be. If the court overrules Grutter, will the military have a difficult will have to repeat. If the court overrules Grutter, will the military have difficulty recruiting a diverse armed service?
If the court overrules the military, the military will have a particularly difficult time recruiting a diverse group of military leaders to lead an already greatly diverse group of enlisted soldiers, which would fracture camaraderie and be a threat to national security. Indeed, the Department of Defense in a recent memo emphasized that having a fighting force that is diverse in all respects, including race, is integral to overall readiness and mission accomplishments. And that diversity is a strategic imperative that is essential to achieving a mission-ready fighting force in the 21st century. Indeed, our country's history shows that the disparity in racial diversity between officers and enlisted soldiers can be deadly. In the Vietnam War, for instance, racial tensions seriously jeopardized the war effort because the officer class was almost exclusively white, while the enlisted soldiers were highly diverse. The military's own report showed that lacks of diversity in the military leadership led to perception of racial ethnic minorities serving as cannon fodder for white military leaders, and delegitimized the military. Several fights broke out between black and white soldiers during the war, injuring dozens, killing several, and severely diminishing morale. Because commissioned officers generally must have a bachelor's degree from a university, diversity in higher education is crucial to diversity in the group of individuals who can and will become the military leaders of the future. Over 80% of these leaders come from civilian schools like the University of North Carolina. As we've previously mentioned, racial diversity would plummet in the absence of race-conscious admissions policies. This means that in the absence of race-conscious admissions policies, the government would have a vastly smaller pool from which to draw a diverse group of future military leaders.